Pen you all the black pen. I'm getting tired just thinking about this topic. I'm going to be reading 1, 2, 3, 4, 5, 6, 7. I'm going to be reading 7 articles, which I hope will be educational for you guys. Anyone who follows me on social media will know that I do not believe in the marriage contract. I think the whole concept of getting married, not marriage, married. The whole concept of getting married and marriage is outdated. And I think we need to be looking into new constructs of the family. I do believe in the nuclear family. I do believe in one man, one woman coming together, deciding maturely, planning to live together, deciding to start a family, have children. And then, of course, involving all types of stakeholders in that. Their siblings, their friends, and other relevant parties to say, I'm now going to be living with this person, we are starting a family. I do not believe in the marriage contract as it currently stands. I do not believe in a lot of the laws around marriage and divorce. And when you look at how the world is moving and changing and evolving, I think we need to have more intelligent constructs and contracts, if we are going to have contracts, regarding couples, romance, children, families, etc. So I decided to make this video not for that. I decided to make this video for the people that still believe in marriage, people that, for whatever reason, are sadly going to be going through a divorce, people that are going to lose their loved ones, whether they are married or not, and then other dynamics around it. I've written 6 topics here that I'm hoping will be uncovered as I read these articles, and I hope you'll bear with me. Number 1, the history of marriage. I'm going to try and go through this as briefly as I can for you to understand where this concept of marriage comes from as we have it today. Number 2, people may not know this in South Africa, but husbands can now take their wives' surnames. There have been breakthrough cases in that, and I'm going to read an article on that as well. Number 3, this is relatively new. The courts can now override the prenup contract or the antenuptial agreements during divorce proceedings. So where you said we're separating our things, the courts can say, no, don't move too fast. We know you guys signed this thing, but there are laws that can challenge that now. I'm going to read an article or a few about that. Number 4, treating a girlfriend, boyfriend, spouse as a wife, husband, or married spouse upon death, and sometimes even during divorce. Very interesting cases and thoughts and amendments to laws that are going to be affecting a lot of people living with their partners, even though they're not married. There, you guys are in trouble. Number 5, legalizing polyandry. Polygamy, the concept, is an overarching term which speaks about one spouse having more than one marital spouse. That's polygamy. It's not gender specific. Polygyny is the one that's popular in the world, where a man has more than one wife. Where a woman has more than one husband, that is called polyandry. And in South Africa, there are calls for the legalization of polyandry. A woman can have more than one husband. Number 6, Muslim marriages now to be recognized legally where they were not in the past, and how that impacts the divorces or the splitting of Muslim couples as well. Let's go with the first one, the history of marriage. This is from Wikipedia. Marriage, also called matrimony or wedlock, is a culturally and often legally recognized union between people called spouses. It establishes rights and obligations between them, as well as between them and their children, if there are any, and between them and their in-laws. It is nearly a cultural, but it's nearly culturally universal, but the definition of marriage varies between cultures and religions and over time. Typically, it is an institution in which interpersonal relationships, usually sexual, are acknowledged or sanctioned. In some cultures, marriage is recommended or considered to be compulsory before pursuing sexual activity. A marriage ceremony is called a wedding, while a private marriage is sometimes called an elopement. You guys ran away to go get married. Very important. In some cultures, in many cultures, at least in the South African context. If you're an African, if you're black, all of your cultures, if you are a Christian, if you are a Muslim, if you are Jewish, this all applies to you. Marriage is recommended or considered to be compulsory. It's actually compulsory before pursuing any sexual activity. Very important. Let me start with the first article. I hope this stuff will load quickly. This is from theweek.com. Let's see here. Last updated in July 2025. Written by Justin Clowance, or Clarence. I think Peter Weber as well, I'm not sure, but theweek.com. Article is, when did marriage begin? Subheading, evidence suggests marriage is at least 4,300 years old. While interhuman relationships go back to the early years of civilization, marriage has only become commonplace in the recent annals of history. Evidence suggests that marriage as an institution may only be several thousand years old, just a small blip on humanity's 300,000-year-old timeline. And the general idea that one man and one woman would spend their whole lives together has only cropped up in the last few centuries. Many of the modern partner trends, like polyamory and thruples, are actually variations on historical marriage tropes. Also taking root in historical precedents are fads like the tradwife movement, which has been making waves on social media, but even newer than the idea of marriage. The idea that you'd marry someone because you actually love them is very new, very new. How old is marriage as an institution? The best available evidence suggests that it is about 4,350 years old. For thousands of years before that, most anthropologists believe families consisted of loosely organized groups of as many as 30 people, with several male leaders, multiple women shared between them, and children. As hunter-gatherers settled down into agrarian civilizations, society had a need for more stable arrangements. The first recorded evidence of marriage ceremonies uniting one woman and one man dates from about 2350 BC in Mesopotamia. Over the next several hundred years, marriage evolved into a widespread institution embraced by the ancient Hebrews, Greeks, and Romans. But back then, marriage had little to do with love or with religion. If marriage wasn't about love, what was it about? Marriage's primary purpose was to bind women to men, and thus guarantee that a man's children were truly his biological heirs. This was particularly important in patriarchal societies, where these heirs would often inherit leadership roles. Through marriage, a woman became a man's property. In the betrothal ceremony of ancient Greece, a father would hand over his daughter with these words: I pledge my daughter for the purpose of producing legitimate offspring. Very important, and one of the things I normally say to people is, if you look at the history of marriage and the marriage contract, it existed at a time where we were class citizens. Thus, the woman would become property, and it would be her as the property of her father being handed over to a man to become her property, which is why to this day we speak about women taking a man's surname. She would take her father's under her father's or ownership, and then she would be handed over to be her husband's, to take her husband's surname and become her husband's property. Mrs. Whoever, and you wear a ring, is to signify to people, I belong to someone. And this whole idea that women are like, I want to wear his surname. You're property, like any other property, historically, at the very least. And then it says here also to ensure when I take this woman, this girl, the offspring will be legitimate. They will be mine. She will not have been sleeping with random people out in the streets, such that we don't know who the father of the child or the children are or is. Among the ancient Hebrews, men were free to take several wives. Married Greek and Roman men were free to satisfy their sexual urges with concubines, prostitutes, and even teenage male lovers, while their wives were required to stay home and tend to the household. So in Greek and Rome, the men would sleep with concubines, with prostitutes, and even have gay sex with other young men. If wives failed to produce offspring, their husbands could give them back and marry someone else. Rough. When did religion become involved? As the Christian church became a powerful institution in Europe, the blessings of a priest became increasingly common. Through the years, there have been differing views about whether weddings are primarily religious or secular events, said the Christian-based Nelson University. For much of the early Christian era, the church stayed out of weddings and let the state handle the union of man and woman. But by the 8th century, Christian churches started to perform weddings, and the ritual became widely accepted as sacrament. While some religions may view marriage differently, they often share similar characteristics. Marriage is highly valued in Jewish culture, and the wedding is one of the most important events in the life cycle, according to the University of Chicago, despite the fact that no wedding ceremony is described in the Torah, the official scriptures of the Jewish faith. But the institution of marriage began with Adam and Eve, said reformjudaism.org. Likewise, marriage in Islam is an essential pillar of human life, as humans are the masters of creatures and the most honorable of them, said the Imam Mahdi Association of Majaya. A successful Muslim marriage is a purposeful one and not one based on emotions and fleeting desires. Beyond religion, varying cultures also have unique customs when it comes to marriage. In Scotland, a tradition called the blackening occurs when friends and family seized the engaged couple and gunk them with anything from rotten eggs and fish guts to manure and molasses, said the BBC. And in certain Chinese provinces, there's a ceremonial practice involving sobbing and singing by the bride and her family, where the bride may cry intermittently, with her tears seen as an expression of gratitude, said the South China Morning Post. When did the state get involved? The shift from common law marriages where two people or their families simply declared they were married to legal marriage began in the church with the calling of banns or public announcements before the marriage in the 13th century. By the end of the Middle Ages, written marriage contracts had become a regular part of the marriage process, said Jessica Levy at American Marriage Ministries. That's the 13th century. Just like you guys decide between the two of you, this is my boyfriend, this is my girlfriend, this is my lover, without having to involve the state, without having to involve the church, it would be just you and the person. And then sometimes you'd let your friends know, you'd let your family know, and everyone would know that is a couple. It would be in the 13th century that all of a sudden, the whole concept of marriage now needs to involve the state and the church. Marriage licenses arrived in the United States in the colonial era, recording marriages at the local level in 1639 and statewide 2 years later. According to the University of Massachusetts Amherst, at the time, the husband's dominance was recognized under a legal doctrine called coverture, under which the new bride's identity was absorbed into his. Great Britain introduced non-religion civil marriage in the Marriage Act of 1836. By 1929, all US states had laws on marriage licenses. Marriage became a federal issue with the introduction of the Married Couple Income Tax Filing in 1913. When did love enter the picture? You guys, I'm marrying him because I love him. As previously mentioned, marriage was viewed in ancient times as a binding contract between a man and a woman. But in the 18th century, society encouraged young people to select their marriage partners based on their romantic attachments. 18th century, said the National Women's History Museum. This represented a notable change from prior eras, when the bride's and groom's feelings were not of paramount consideration when it came to selecting a partner. As parents and guardians took a back seat in attempting to find partners for their children, lovers needed to find one another and then determine the extent of mutual attraction. This is also when courtships became a significant part of finding a spouse. Since then, romance and attraction have become synonymous with marriage and weddings. This is obviously an American article, but if you think of it even in the African context, for us Africans, the whole concept of getting married for some people, even to this day, is not so much about romance, but very much about the building of family. That is why you would have things such as arranged marriages, where the two families come together. They say, we would like to bond as families and we will give of each other's children, a male and a female, to unionize us as families. It's why also certain well-off, wealthy men or men of stature would have multiple wives because the families would pledge their daughters saying, we would love for our daughter to get into royalty, saying that our family is now linked and related to royalty. There would be circumstances where, because we couldn't hire nannies, we couldn't hire babysitters and school teachers and the like, when women were needed in the household to take care of old people, to look after the children, to help work in the fields, etc., men would go and acquire more wives. Sometimes these wives would be brought by their existing wives to say, Baba, I have found a woman or a young girl that I think would be very valuable to this family. Please, may we adopt her into this family, where then you would start this process of speaking to the other family and making sure that the families agree that we are handing over our daughter as handpicked by your wife or as handpicked by you to come and serve your family. Later on, you then have conversations around, should we be having sex? Should we be having children? Or was this woman just brought in here just to come and help around the household? Let's see if there's anything else I want to read here. I'll close off here for LGBTQI+. Marriage has taken even more of a swing in the last 50 years, particularly when it comes to the wider acceptance of same-sex marriages. While the LGBTQI+ community has been pushing for marriage equality for years, it was only in 2001 that the Netherlands became the first country in the world to legalize same-sex weddings. Other nations have followed, and particularly in the United States, people gave our all to ensure every person, regardless of whom they love, is recognized equally under the law, said Human Rights Watch. The moment for full marriage equality in the US finally arrived June 26, 2015, when the Supreme Court granted same-sex couples in all 50 states the right to full equal recognition under the law. Cheers. It was written by Peter Weber, The Week, updated by Justin Clowens, July 10th, 2025. That's the first article that I'm going to read. I said I'm going to be reading 7, but that just gives a generic history of where marriage comes from, how the contracts came about, how religion got involved, how the state got involved, and how at some point romance and love got involved, and it almost becomes one of the last steps, and how as of recently we now have same-sex marriages that are recognized in the law. Okay, that covers the history of marriage, number 1. Number 2, men can now take women's surnames. Woo! I think I saw this on Twitter, if I'm not mistaken, and the number of men being aggressive in this, saying this is wrong, this is rubbish, I found tickling me, very interesting, and exposing to me how people are ignorant about where surnames come from, what surnames mean, and how many men are still rooted in patriarchy. In the African context, and specifically in South Africa, and specifically because I was raised as a Zulu boy, we did not have surnames. Surnames become a colonial construct with the British and other European people coming to South Africa. What happened in the past is that you as a child would be given a name or names by your family, and then you would be identified by your father's name. And if not your father's name, you'd be identified where you come in, your family you come from, your family totem, etc. And this is not unique to Africa. If you look at surnames in the Netherlands and in Dutch areas in Holland, your van der Merwe, the van der is from. This would hold in so many different. There would be surnames in the UK, blacksmith, goldsmith, which would signify the career or what or the skill set that your family is known for. In places like Iceland, if I'm not mistaken, you see this when you're watching football games. You'll see surnames that have son at the end. Johnson, Johansson. That son is the son of, and it would be the father's name to this day. So when you see surnames like Johnson, Richardson, that used to be the son of Richard or the son of John. That is where these surnames come. We did not have surnames. Surnames become new in the African context. That's why when we speak, my prime example, King Shaka would be known as Ushaga, Kasenza Ngakona, Usenza Ngakona being his father's name, Usenza Ngakona Gajama, Ujama being his father's name. It was not Shaka Zulu. He did not have a surname. It was Shaka Kasenza Ngakona, the king of the Zulu nation, which would be a nation named after the heavens, a nation named after one of their forefathers, Uzulu, Kamalandela, his father being Umalandela. But then you fast forward to colonialism taking root, the formalization of South Africa as a union, and today we have surnames. And in doing that surname thing, we also took on these habits that I just spoke of now, where when you get married, all of a sudden now the woman wants to take your surname. That thing has to do with a man's name. There are young boys today who pride themselves in their surnames, only to find out that that surname is not his father's name. It comes from the mother's side. And you say, it's the mom's surname. The mom doesn't have a surname or does not have a name. In South Africa, we do not have women that give names. Silly examples. You do not have children whose surnames have a feminine link. Sbongile, Palesa, Naledi, Umbalenhle. We don't have surnames like that because the surnames were not given after the mother's name. The surnames were given after the father's name. And we have not been able to evolve and transition beyond that from a surname perspective to say, if a surname carries such weight, does it represent my culture? Does it represent my geography? Does it represent my values? Does it notify or denote my father or both my parents, or where we come from and what we believe in? And if that is not the case, are surnames still relevant today? And that can become a conversation for another day. dailymaverick.co.za. Headline: Case to allow a husband to take the wife's surname reaches the Constitutional Court. This was written in March 2025 by Surname. South African men cannot at present take their wife's surname or have their surnames hyphenated. The Constitutional Court appears likely to change that. All two men wanted to do was to take their wife's surname until they found out, according to Home Affairs, that they could not. Now, the case has been taken to the country's apex court. The couples at the center of the application claim in court papers that the Births and Deaths Registration Act of 1992, which provides for a change in the surname only when there is a change in the marital status of a woman, is unconstitutional. According to court papers, such laws and regulations perpetuate gender norms set by a patriarchal society that entrenches gender inequality, according to the applicants. They called for regulations, I'm not going to cite the numbers, to be declared unconstitutional as it discriminates against men by failing to provide them for the change of the marital status of a man. This matter was heard in the Constitutional Court on Tuesday, 4th of March 2025, where the court was asked to give a confirmation order of a previous ruling in the Free State High Court, which in September 2024 ordered that a man could assume his wife's surname or have a double-barreled surname. Both the Ministers of Home Affairs and Justice and Constitutional Development said they would respect the decision of the court. Currently, the position is that the husband may not take his wife's surname except after an application to the Director General of the Department of Home Affairs, which may or may not be declined, depending on whether the director is of the view that good and sufficient reason exists. At the same time, according to court papers, this position precludes the change of a surname where a man marries another man and thus wishes to assume his husband's surname. So it currently precludes that change. I'll read you the stories because we're here to be storytellers and to tell you that these things. The Jordans. One of the applicants in the case, Jana Jordan, decided not to change her surname after marriage. Her parents died when she was 4 years old, and in her founding affidavit symbolized my connection to them. She explained this to her partner, Henry van der Merwe, who in turn pledged his support for this decision. The second applicant in turn expressed his wish to one day assume my surname at the time of our marriage so that we can become the Jordan family and raise our children with that surname, said Jordan's founding affidavit. The pair were married in July 2021. According to the court papers, after their marriage was solemnized and was in the process of registration, a member of the Department of Home Affairs asked if she was to retain her surname or assume her husband's surname. The couple informed that van der Merwe would be taking his wife's surname. They were met with, "The system does not allow that. Umthetho awuvumi, chief." The Home Affairs staff member accompanied them to the General Department for assistance, where they were then told by a second official that the application to assume the Jordan surname could not be processed. In the papers, Jordan stated, "It was a very emotional and ultimately upsetting end to a wonderful day. I was devastated and powerless as I realized that regardless of whether the staff members wanted to assist us they simply did not have the power to do so. As a result, the couple have different surnames, while their daughter carries the van der Merwe surname. At one point, Jordaan's surname was reflected as van der Merwe by Home Affairs. She had discovered this only in October 2021 when she checked a voter registration portal. This was not her intention, not that she requested this change. Before I go to the next story, I've sat with Tibucho Kibine, who I film Convo with at Tribal Media House, and he has spoken and alluded to surnames should have power and weight. And where a woman's surname, her family name, where she comes from, carries weight and stature in society, perhaps men should looking into taking that surname. In South Africa, you look at two prime surnames, the Motsepe family, who are the wealthiest African family in South Africa. You look at the Mandela family of Nelson Mandela. With the Motsepes, it's pretty clear. Patrice Motsepe is the wealthiest black man in South Africa. If ever he had a daughter, the question would be, as a man, would you be comfortable taking this Motsepe surname so that you are linked with a wealthy, successful, politically connected family? The Mandela family, you find, and people can correct me if I'm wrong, many of the grandchildren and great-grandchildren of Nelson Mandela, the daughters in particular, would go and get married, however, would retain their surname of Mandela because it would open many doors and give them status in society. And their children, male or female, boys and girls, would still retain the surname of Mandela to ensure that out there in society, people see the surname and they say, oh my gosh, are you related to the great icon, the late Nelson Rolihlahla Mandela? And the kids would say, yes, that's my grandfather, that's my great-grandfather. You would assume, oh, that means your mom never got married. No, she did. But we decided to keep this surname. And the conversation around when you're taking on a family name on a surname, should you go for one, as with the Jordaans, that has symbolic value? Should you go for one that has a higher status link in society? Or should there be some situation where you're saying, I don't know who I am, I'm an orphan. I was given a surname, I don't know who my parents are. So when I do get married, I will take my partner's surname because at least there's a family history and a lineage there, whereas there isn't one here. Or maybe you just don't want to be associated with your family. You look at surnames like Hitler, you look at surnames of, let's say, for people that believe he was a bad man, Robert Mugabe. Everywhere you go now, you've got the surname of Mugabe, and maybe people treat you in a negative light because of this surname link. The Donnelly Borman family. The other couple at the center of this case is Jess Donnelly Borman and Andreas Borman. Jess Donnelly's maiden name held significant importance to her as an only child. Before their marriage, she expressed that she wanted to keep her maiden surname and would prefer to hyphenate her husband's surname, that's double barrel. The couple did separate surnames, nor did they want to have different surnames of their future children. The pair decided to combine their surnames to reflect their new family unit to Donnelly Borman. The couple were married in 2022. After a honeymoon, they went to Home Affairs in Botshabelo in July 2022 as she needed a new identity document and passport which reflected her new surname, while her husband tried to apply to change his name to the new family name of Donnelly Borman. According to court papers, a Home Affairs representative informed the couple that he couldn't change Andreas Borman's surname. The couple did not receive clarity on why this was impossible. When they returned to collect her new documents, they tried to speak to anyone who could assist them, but were told it was simply impossible for Borman to change his surname or assume his wife's surname. They had gone to Home Affairs in George during October 2022, where they were told that under the Births and Deaths Registration Act 51 of 1992, this was not permitted. According to the court papers, the couple were given an email address to contact the Office of the Director General to inquire if there was anything that could be done or to request guidance. The couple sent the email in October 2022, but according to their court papers, no response has however been received to that email to date. Equality and dignity. The applicants contend that the fact that men cannot take their wives' surnames is inconsistent with provisions of sections 9 and 10 of the Constitution, which deal with equality and dignity. According to the court papers, the applicants state gender discrimination, not only in our society, but historically is well established and entrenched. The applicants go further and claim that the acts and regulations undeniably differentiate between people or groups of people. They differentiate on the basis of sex and gender. They question what legitimate government purpose is served by the differentiation, in that the Act and regulations preclude the assumption of the surname of a woman by a man. There is no cogent, rationally defensible purpose that the applicants could find. This differentiation is tantamount to unfair discrimination and can no longer be tolerated, they say. Do I want to read anything more here? I'm not sure what happened to this case, but something very, very important again, dailymaverick.co.za. And for any of you, look, changing your surname is not the most difficult thing. At face value, go to Home Affairs, especially if you have your mom's surname and you want your dad's surname. They'll ask for your father's ID, etc., and then you do a change. They advertise in the government gazette, etc. There becomes a problem when you want to create a new surname, which is something that I wanted to do in the past. Conversation for another day. If your surname does not exist in public, they cannot change your surname unless you write to the minister or the director general. It becomes tedious and almost impossible. They say, no, whatever surname you want must represent a group of people that already exist out there and who can verify that, yes, Penal is a Mutsipe, please change his surname. Penal is a Mandela, please change his surname. So those are some of the things that we need to look into, some of the things that are being fought, that the law has to change, that Home Affairs has to change, to say, if you want to change your surname. I'm looking forward to a future where, if we still have surnames, women's names become the surnames, to say all the surnames, the ones even that I referenced, are masculine and patriarchal. Your surname should be Jessica, it should be Elizabeth. As I said, it should be Naledi, Palisa, it should be Standiwe. And that's your surname, and there's nothing wrong with it. The next, let's see, what's this? 1, 2, 3 articles, of which I know some of them overlap, are going to cover this. Courts can override the prenup during divorce and treating a girlfriend, boyfriend as a wife, husband upon death. I'm going to leave the last two. Oh no, not even the last two, the last one. The last one is Muslim marriage is now to be recognized legally. It's going to come up in one of the articles or in two of the articles. And then the last one I'm going to be raising is legalizing polyandry, which is going to be the last article that I read. Let me maybe start with that one, because this other one is quite heavy. And this one is more niche. Legalizing polyandry. I hope you guys will appreciate some of this education. You can read these articles. I'm going to post the links in the description. But for people that don't read, for people that just like listening to someone speak, I hope that this can be educational to yourself, to your family members, and to other people that can benefit from this information. womenandhomemagazine.co.za, May 13, 2025. KZN woman marries 2 men and advocates for the legalization of polyandry. In a challenge to South Africa's marriage laws, a Durban woman has made headlines by symbolically marrying her second husband while remaining legally wed to her first. Jolene Geldenes, a 34-year-old known as the Pink Pitbull in boxing circles, is advocating for the legal recognition of polyandry, the practice of a woman having multiple husbands. In a country where polygamy for men is permitted, polyandry remains outlawed. Speaking out for polyandrous thruples, couple, thruple, maths 2, 3. On April 26, Geldenes celebrated a traditional, non-legally binding wedding with her boxing coach, Santini Lee, age 38, at Salmon Bay in Ballito. She continues to be legally married to Jack Geldenes, 37, her husband of 12 years and the father of her 4 children. The trio, along with the children, live together in La Mercy, Durban, in a polyamorous arrangement that challenges societal norms and trends in South Africa. Geldenes' journey to this unconventional family dynamic was not without hardship. After she endured an abusive relationship with a former high school sweetheart, boxing became her refuge where she would meet Lee, who helped her heal and rebuild her life. Rather than divorcing Jack, the couple reconciled and welcomed Lee into their family, creating a throuple built on mutual respect and open communication. Despite the trio's harmonious union, polyandry still remains outlawed in South Africa, as Geldenes advocates for equality. Polyandry is more than a legal issue. It's cultural and societal, she says, as per the North Coast Courier. I've received messages from other couples who are afraid to speak out. That's why I will continue to advocate for recognition of polyandrous relationships, adds Geldenes. Laws around polyandry in South Africa. As per News 24, South Africa's marriage laws, particularly the Recognition of Customary Marriages Act of 1998, they extend the same right to women. This double standard has sparked debate with a 2021 Department of Home Affairs Green Paper proposing polyandry's legalization. The proposal faced significant backlash, with critics arguing it would disrupt traditional family structures and African cultural values. Despite the criticism, Geldenes remains sure-footed in her advocacy. Drawing inspiration from the LGBTQ+, she uses her growing social media platform, particularly on TikTok, to advocate for marriage equality. Her openness has resonated with others in similar relationships who fear societal judgment. Documentary on the way. While Geldenes lacks the resources to challenge the law in court, she hopes her story will inspire change. A documentary series currently in production by 32 Done Productions and directed by Simone Ross will explore the family's history, including the childhood traumas that shaped their perspectives on love. By sharing my story, I hope to inspire change, says Geldenes. womenandhomemagazine.co.za. Let me go to the next article. Would be interesting to hear what you guys think of polyandry. I know, just as a concern for people like myself, polygyny, where a man has more than one wife, is easier when it comes to children and sex, because a man can impregnate multiple women and we can know this is the father of the children. Where a woman is in a polyandrous situation, if she decides to have children and she has unprotected sex, does she have unprotected sex with the man she's trying to have a child with, so that it is known that we are trying to have a child? Or is she having unprotected sex with both men, all three men, whereby once she falls pregnant, it's going to become difficult to know who the child is, and a paternity DNA test will be done? Outside of that, it almost is fair play to say, if men can have multiple partners, why can't women do that? And in a time where women can make their own money, in a time where women are leaders, in a time where women are powerful, why can't a woman, Oprah Winfrey, why can't a woman who is strong, who has great leadership, who makes a lot of money, take on more than one husband? Because she is saying, I'm a provider. I will take care of my family. I am in love with two men. They love me. I've told them that I love both of them, and I want to marry the one, but the other one also feels like my husband. I'd like to marry both of them. And I'll find a way, just like other men do, to make sure that I spend equal time with both of them, or we all live in one household. You look at Umusam Tombeni and Uthando Nesithembu as a reality show on TV, and you try to imagine Umusam Tombeni being a woman married with multiple husbands, and that reality show showing us the dynamics and the stresses and the fights and the happy memories of being in such a union. The next couple of articles I'm going to read might have some repetition, and I apologize where I'm going to be repeating stuff. If I am cognizant of it, I'll just skim past it very quickly. Otherwise, I'll just be repeating. Moonstone.co.za, posted on 13 January 2022 by Mark Beckard. Parliament ordered to change South Africa's maintenance and inheritance laws. The Constitutional Court has given Parliament 18 months, this was in 2022, 18 months to amend the Interstate Succession Act and the Maintenance of Surviving Spouses Act so that both laws provide for permanent life partners. In a judgment handed down on the last day of 2021, the court found that Section 1 of the Maintenance of Surviving Spouses Act and Section 1, bracket 1 of the Interstate Succession Act were unconstitutional and invalid because both sections excluded permanent life partners. The court ordered that the definition of survivor in Section 1 of the Maintenance of Surviving Spouses Act is to be read as if it included the following words after the words dissolved by death and includes the surviving partner of a permanent life partnership terminated by the death of one partner, in which the partners undertook reciprocal duties of support, and in circumstances where the surviving partner has not received an equitable share in the deceased partner's estate. Section 1 of the Act is to be read as though it included the following at the end of the existing section definition. Spouse, for the purposes of this Act, shall include a person in a permanent life partnership in which the partners undertook reciprocal duties of support. Number 2, marriage, for the purposes of this Act, shall include a permanent life partnership in which the partners undertook reciprocal duties of support. Section 1, bracket 1 of the Interstate Succession Act is to be read as though the following words appear after the word spouse, whether it appears in the section, or partner in a permanent life partnership in which the partners have undertaken reciprocal duties of support. The case was brought by Jane Boanya, who sought leave to appeal directly to the Constitutional Court against the Western Cape High Court's dismissal of a challenge to the constitutionality of the definition of survivor under the Act. Boanya also asked the court to confirm a declaration by the High Court that the section of the Interstate Succession Act is constitutionally invalid to the extent that it excludes surviving partners in a permanent heterosexual life partnership in which the partners had undertaken reciprocal duties of support from inheriting in terms of the Act. I'm going to go into the story now. People are getting married. People get married for many reasons, one of them being to actually protect their assets, to make sure that their children are within a marriage and there's going to be no issues once they get divorced or once one of them passes away. We are looking into now, and what was being challenged was this idea that if I'm living with my girlfriend, boyfriend, we are not legally married, but we live as if we are married. We both contribute towards rent. We both have a joint bond. We've been living together for maybe 5 years. We have got children. At some point, the man was unemployed and the woman was taking care of him financially. At some point, the woman was unemployed and the man was taking care of her financially. We are living as if we are married. The laws should reflect that we are doing that, because it cannot be that you've been living with a partner that you love, that you're committed to for 10 years, and you guys take care of each other for 10 years and you have children. But your union is deemed lesser in the law than a couple that met a month ago, and then decided last week to get married and they've got no children. And when the law comes into effect, if in both cases one partner dies, in this one where you guys have been married for a week, the law sees that as more serious as the remaining spouse inheriting versus this other one. And that's what. Let me read the story. Committed relationship. Boanya and Anthony Ruch were involved in a committed relationship for 2 years. In November 2015, they planned to get married. However, Ruch, I'll call him Ruch for now. I apologize for the pronunciation. Ruch died in April 2016, 2 months before they were scheduled to travel to Zimbabwe so that lobola negotiations could start. And in his will, Ruch nominated his mother as the sole heir to his estate. However, his mother had predeceased him, so his mother passed away before him. Boanya lodged 2 claims against Ruch's estate in terms of the Administration of Estates Act, for maintenance in terms of the Maintenance of Surviving Spouses Act, and for inheritance in terms of the Interstate Succession Act. She based the claims on the fact that her permanent life partnership with Ruch was akin to a marriage, and that they'd undertaken reciprocal duties of support towards each other. The executor of Ruch's estate rejected both claims because in terms of the acts, Boanya did not qualify for the claimed benefits. You'd find a similar argument with the surviving spouse of the late Ricky Rick, a very famous hip-hop artist and musician in South Africa, Bianca Naidoo, who wanted to be the executor or the executrix of his estate, but was denied because they were not legally married. And she went and challenged that to say, but we were permanent life partners. We were living as if we were married. We have children. And she won the case. Constitutional challenge. Boanya challenged the constitutionality of the sections. She argued that the 2 acts are unconstitutional to the extent that they exclude surviving partners in permanent heterosexual life partnerships. That heterosexual must be read with an asterisk, because I can only imagine that homosexual partners are also going to be coming for this and saying it can't be that only straight people get protected here if it changes. Please include us as well. I'm a man. My boyfriend and I have been together for 3-5 years. We never got married. We took care of each other. We maybe even adopted a child. And it cannot be that I cannot inherit or I cannot be maintained by their deceased estate. Where the partners had undertaken reciprocal duties of support were taking care of each other from claiming maintenance and inheritance from the estates. Let's see here. The basis of the claim was that the exclusions under the two acts violated her rights to equality and dignity. Before the High Court disposed of the matter, Upwanya and the executor and Richard's relatives entered into a settlement agreement, which was made an order of the court. In terms of this agreement, Upwanya was awarded 3 million rand. The High Court dismissed the challenge to the constitutionality of maintenance, mainly because it was bound by the Constitutional Court's judgment in another case, Folks N.O. versus Robinson and others of 2005. It found the Interstate Succession Act inconsistent with the Constitution and declared it invalid to the extent that excluded permanent life partnerships. See, I don't know if I want to read the rest of this. I think I've made my point, or I've raised the important point in this, that at the time, Parliament was asked to review this. I'm not sure if it has been reviewed, but it's something to look into. We speak about common law spouses, and last I checked in South Africa, we don't have that. Every now and then, there will be stories trending online. Be careful, your boyfriend that you're living with, your girlfriend you're living with, if something happens to you, they'll inherit all your stuff. That is not legally correct, but people can challenge some of these things in the court. And if you challenge things in the court, even if they are not law, the judge can set a precedent where it then becomes case law moving forward. What does this mean? It means just because a certain law doesn't exist, doesn't mean it can be brought to life. You can go and ask, as with the case of a man taking on a woman's surname, can this be done? No, it cannot be done. The law does not allow it. Understood. What are the acts? What are the laws that do not allow it to be done? They reference them. After they reference, you ask, is this in line with the Constitution? Is this in line with human rights? Is this in line with morality, etc.? And you can take that case, find a lawyer, find a law firm, and go and challenge this. Magistrates Court, High Court, Supreme Court of Appeal, and the Constitutional Court. And you and your situation in your life can create a new law in South Africa that can assist so many other people moving forward. Don't just turn around when someone says this is illegal, this is not allowed. Go and challenge it, because laws are created by human beings and can be amended, changed, and removed by human beings if you can give a valid argument that can be bought into by the powers that be. Last 3 articles that I'm going to be reading. First one, be able to override anti-nuptial contracts. Number 2, new divorce laws for South Africa. Number 3, big changes to who gets what after divorce in South Africa. These last 2 from Business Tech, there's probably going to be overlapping. I'm going to read them last. Let me start with this one from Moonstone again. Bit technical, and I apologize, but I'm hoping educational, because when I read these, I'm like, you know, if you don't know these things, you could find yourself in big trouble. Know these things, tell other people. You could save someone's life. You could save someone from spending tens to hundreds of thousands, if not millions of rands, fighting some of these matters in court when they could have avoided them. It's like that thing of abstinence is king. Before you have to deal with morning after pills and abortions and fighting over paternity and dealing with co-parenting, prevention is better than cure. Make sure that you understand the law, and before you go and get married, before you move in with someone, before you at least understand these laws that affect you, that affect your spouse, that affect your children, so that you guys can plan accordingly for these things. Moonstone.co.za. This is from July 2025. Headline: Courts will be able to override anti-nuptial contracts upon divorce. Oh, julle is in kakstraat, my maat. Julle gaan kak hoor. South Africa's divorce and property laws are set for a major overhaul to ensure fairer asset division. If you're getting divorced, reviewing your anti-nuptial contract, or finalizing a deceased spouse's estate, the upcoming changes could significantly impact your financial rights. In June 2025, the Minister of Justice and Constitutional Development, Minister Mamoloko Kubai, announced that the General Laws Family Matters Amendment Bill will soon be tabled in Parliament. The bill is expected to be introduced and processed within this year. The reforms stem from a 2023 Constitutional Court ruling and aim to protect spouses, particularly those married out of community of property without accrual, who are often left with nothing after divorce or death, despite years of non-financial contributions to the marriage. The bill proposes amendments to the Divorce Act, the Matrimonial Property Act, and the Mediation in Certain Divorce Matters Act. It will give courts greater powers to redistribute assets fairly and will be particularly beneficial to spouses in pre-1984 marriages and those who excluded accrual in their antenuptial contracts. What the proposed divorce law reforms will change. Bertus Preller, a family and divorce law attorney and mediator at Morris Phillips Weisenberg, outlined the impact of the proposed amendments in a recent blog post. He says the central change is that the courts will be empowered to redistribute assets in certain marriages out of community of property without accrual. Currently, this marital regime leaves some spouses with no legal claim to assets despite their non-financial contributions to the marriage. Put very simply, you guys decide that you want to get married. The person, husband or wife, who maybe has assets, who maybe earns very well, is like, you know what, we need to write a prenup. We need to have an antenuptial contract. Maybe I've got other children from a previous relationship. I would like to protect us from anything happening between me and you. People get divorced. I may pass away. You might get married again. I need to protect my family and so let's draft this thing. So you guys agree. We will draft this contract. It keeps our assets separate. And there is with accrual, meaning that whatever we accumulate after we get married, we will share. Without accrual, saying whatever we accumulate after marriage, we still keep separate. And as it stands in the law now, if that is the case, as a woman, you marry big baller, CEO, makes a lot of money, earns R1 million a month. Maybe he's got other kids, maybe not. You guys have kids. You guys get married, get an antenuptial contract without accrual. When he passes on, you do not automatically inherit what he has. If he didn't write you in the will, unfortunately, you will have to fight and. The law doesn't counter for that. And the courts would have their hands tied because would say, but ma'am, you guys signed an antenuptial contract without accrual. So unfortunately, you do not have rights to this guy's stuff. We will wind up the estate. We will see what creditors need to be paid. We'll look at his dependents. And then if you can maybe lodge, I also need something, we will review it. But the contract says, this woman's not getting anything. Right now, the law is looking to be changed to say, we see the contract, we acknowledge it, but we are saying that the courts, the judges, are going to have a right to say, even though we see this contract, and even though this man has passed on, or you guys have divorced, we will override whatever his wishes were that you guys both signed sober in front of lawyers because we do not think it's fair. The bill addresses two main scenarios. Pre-1984 marriages. For a lot of you, this may not impact, but think of your parents, maybe grandparents, if you're still blessed to have them. Pre-1984 marriages. These older marriages took place before the accrual system was introduced. The bill confirms that the courts will be able to order asset transfers not only on divorce, but also in the event of a spouse's death. Post-1984 marriages, excluding accrual. In cases where couples opted out of accrual through their antenuptial contracts, the court will have the discretion to order asset redistribution if it is considered just and equitable. Additional reforms include Matrimonial Property Act updates. These will explicitly allow asset redistribution with such marriages end in death. Changes to the Mediation in Certain Divorce Matters Act. These will strengthen the role of the Office of the Family Advocate and promote the use of mediation in divorce proceedings. Preller says the most significant change in the proposed legislation is that the courts will be given the power to redistribute assets between spouses married out of community of property without accrual. This applies even when couples have kept their finances entirely separate, often through an antenuptial contract. If such a marriage ends, whether by divorce or death, a judge may award a portion of one spouse's assets to the other. In inverted commas, this is being introduced to protect spouses who supported their partner or the family without owning assets of their own, he explains. The Constitutional Court ruled last year that it's unfair and unconstitutional that these spouses, mostly women who were homemakers, walk away with nothing. So the law is catching up to ensure fairness, close quote. There's a quote from Drake quoting Kobe Bryant. Bitch, you wasn't with me shooting in the gym. And Rick Ross is like, huh, bitch, you wasn't with me shooting in the gym. And it had to do with, before he passed on, Kobe Bryant's ex-wife, if I'm not mistaken, getting a huge chunk, multiples of millions of dollars, if not hundreds of millions of dollars, in the divorce. And Drake and Rick Ross referencing what many people had been saying mainstream to say, why is a woman entitled to all this money that this man has made in his basketball career when she wasn't with him, gymming, working hard, playing in games, becoming a star, and. But part of the argument is maybe they had an arrangement. He said, I will go and make the money. I would like you to take care of our family. I would like you to raise our children. I would like you to give me all the other non-financial, sometimes maybe even financial support when I'm down and out. Therefore, that woman is entitled to some type of fair compensation to say, but I was at home taking care of all the things that if I was not around, you would have had to pay people for. And therefore, I'm entitled to some type of financial contribution or compensation. Preller notes that the reform effectively closes a loophole in the Divorce Act that previously failed to recognize non-financial contributions to a marriage. He adds that the proposed changes go beyond asset redistribution because they also include provisions to recognize all types of marriages, including religious and customary unions, and to strengthen the role of family advocates and mediation in divorce proceedings. It is a comprehensive overhaul to modernize family law in line with recent court decisions and social realities, he says. Hey, the lawyers are going to be licking their lips, where in the past, the families would intervene, maybe the pastor or the priest would intervene, the imam would intervene, where the chief, induna, or the king culturally would intervene. Now it's like I say, lawyer do, courts do. Those guys will resolve this thing. People are going to be making money. Go study law, homie, before AI takes over. Let's see here how the new asset redistribution powers will work. I'm not going to go into this. I think you guys can read this on your own. I'm going to put a link to this article in the description. How do the changes affect antenuptial contracts? Couples will still be able to sign and choose to exclude community of property or the accrual system. That won't change. However, what does change is that an antenuptial contract will no longer be absolute in its effect upon divorce. So the contracts are there, they're valid, they're binding. This person is not entitled to stuff, but it is now not full stop. It is now comma, it is now semicolon, it is now, if it is not equitable and just, if something looks a bit amiss or unfair, it can be challenged and the courts can have power over that. There was point number 6 that I spoke to about the changes in Muslim marriages and the recognition. And I'm going to read this in the same article towards the end. Divorces for Muslim and customary marriages. Historically, Muslim marriages were not recognized under South African civil law. However, an amendment to the Divorce Act in May 2024, literally last year, fully recognized Muslim marriages for the first time. Couples married according to Islamic rites can obtain a divorce decree through the courts just like any other married couple. The courts will ensure that children from such marriages are protected and can order maintenance in a fair division of assets. The law explicitly allows courts to redistribute assets in a Muslim marriage divorce and to apply forfeiture principles for misconduct. He says, so a Muslim wife, for example, who used to have no claim, can now get an equitable share of the marital assets and maintenance for herself and the children. That's a major change. It effectively ended decades of non-recognition. Regarding customary marriages under African customary law, Preller notes that these have been legally recognized since the Recognition of Customary Marriages Act of 1998. He acknowledges that early legislation had some unequal aspects, particularly affecting women in polygamous marriages, but says these issues have since been addressed through amendments. Now, all customary marriages are by default in community of property, meaning wives have equal rights in the property acquired. If a customary marriage ends, the divorce court will divide the assets equally or equitably, and the women are not left out in the cold like in the old days, he says. On same-sex marriages, South Africa has recognized these since 2006 under the Civil Union Act. Preller confirms that same-sex couples have the same divorce rights as heterosexual couples. He sums up, so today, whether your marriage is civil, customary, Muslim, Hindu, same-sex, the law treats them all as valid, and our divorce courts will handle them on an equal footing. The common theme with all these changes is bringing everyone under the umbrella of protection, so that no matter how you were married, you have recourse to a fair divorce process. It may sound like this article is only written for women and to protect women, but I can promise you now the number of people getting divorced where the women were earning more, were taking care of the home, etc., where men can now claim for spousal maintenance, where men are maybe taking custodianship of the children and they are entitled to go and ask for maintenance for the children because women have become bosses. Women are CEOs. Women are charting their own path. But what that means is that now as a woman, when you get married to a man, if you're out earning him, if you have a lot of assets and a lot of wealth, there's a chance that when you get divorced, even if, my dear sister, you've got an antenuptial contract without accrual, that man can go to the court and challenge and get the property and get the cars and get spousal maintenance and other benefits because he will say, yes, I was working, but she was the breadwinner. I was dependent on her. She got me used to this type of life. And therefore, I don't think that with these divorce proceedings that this is fair. Why did I get married? Tyler Perry, Janet Jackson's character and Malik Yoba's character are going through a divorce, and there's money that she has kept to the side from, I think, her book sales, if I'm not mistaken, and her tours. This is fictional. But Malik Yoba's character says, I would like that to be included in the settlement. And she says, no, but I worked hard for this. This is mine. Again, bitch, you wasn't with me shooting in the gym, Kobe Bryant. And he was saying, no, but I was there taking care of the kids. I was there emotionally supporting you. I was there giving you ideas for the books, for your tours. I was even part of the inspiration for some of your work. I'm entitled, just like it would happen the other way around when a woman says, I'm entitled to his earnings because I was his emotional support. I was there giving him ideas. I took care of the kids. I was feeding him. I was driving him into places and I was helping him with his family, his extended family. I would take care of his mom and his dad and his siblings when they had issues. I would take care of his friends when they were around. I'm entitled. So women mustn't think that they are exempt from this. They're going to see flames. We are seeing a lot more cases like this. You look at Minnie Dlamini and Quinton Jones in their divorce, I believe, if I'm not mistaken. I read an article stating that he was asking for, I think, spousal maintenance. I could be mistaken. It could have been child maintenance of about 10,000 Rand per month. We've got situations like Pabi Moloi, who got married, initially denied it, but the Pabi Moloi being a black lady, married to a white man, the white man showing proof. We had the ceremony, there was lobolo, etc. Therefore, we are married. And therefore, I'm entitled, because she owned properties and assets, I'm entitled to some of these things. So before you jump up and down, you're like, oh, girls, we've got it. Watch out, because you might be the one having to pay. I think Mary J. Blige became the most popular, well-off woman who, last I checked, is still paying spousal maintenance. And as women become empowered, as we see more equality, as a hard-working woman who has built up your wealth, please know that once you get married, please know that once you get into a permanent life partnership living with a man, there's a chance that when you guys split, when he moves out, when you get divorced, when you pass away, this man is going to inherit your things, even if you have drafted an antenuptial contract. Kusazo nyiwa. Last two articles. Let's see here. Sorry, this has been a bit long. 1 hour, 5 minutes. Hopefully I should be done in the next 10 or so. Businesstech.co.za. New divorce laws for South Africa, written by Luke Fraser, 17 June 2025. Like I said, I think the next article might be repeating some of the stuff. And if I'm cognizant of it, I'll just skim through it. Justice Minister Mamaloko Kubai is set to introduce new divorce laws for South Africa by tabling the General Family Laws Amendment Bill 2025 to Parliament. So that's something that we read in the previous article. Let me see if there's anything new here. Transfer of assets by court granting a decree of divorce regarding new bill, laws act, mediation, why the changes are needed, married out of community of property, November, okay. Upon death or divorce, however, the Constitutional Court found this to be invalid with the expected amendments, okay. Other big changes. If the new bill passes through Parliament and is assented to, it would mark another significant change to divorce laws, following President Cyril Ramaphosa signing the Divorce Amendment Bill last year, 2024. The Divorce Amendment Bill brought significant changes to Muslim divorces in the country and comes after a lengthy court battle. In the Women's Legal Center Trust versus the President of the Republic of South Africa and others, the Constitutional Court ruled that the act was unconstitutional as it excluded Muslim marriages. The non-recognition of Muslim marriages in civil law meant that a person, particularly a woman who is married in terms of Islamic law, had no right to seek a divorce from a court. Jeez. Al-Jama'ah leader Hanif Hendricks, who introduced a private members bill on the matter, said that Muslim families suffered greatly due to not having the same legal remedies offered in the Divorce Act. Muslim women under Sharia law are often left destitute if a divorce is initiated, as they cannot try to claim patrimonial benefits following dissolution. You know, I praise the Muslim community so much when it comes to their family structures, when it comes to their economic structures and how they're doing well in society and maintaining traditional views. But when you hear some of these stories, you forget that not every person is good. Not every union ends in a non-toxic way. And it's very important when you see a lot of Muslim women who are homemakers, who are housewives, who are taking care of their kids, etc., in a situation where they are being abused physically, where they are being abused emotionally, verbally, psychologically, etc., they can, which they could not before, go and initiate a divorce. I would like to divorce this man. In the past, Sharia law would take effect. They would approach whatever institutions and structures are under the Islamic umbrella. And if it was told, no, you will stay in this marriage, the Quran and Allah needs, it's like, no, I feel that this is oppressive. I feel this is patriarchal. I will go to the courts and say, no, I feel this is wrong. I want to leave. And after leaving, it cannot be that, well, this is Sharia law. You can't just inherit anything. No, the law is saying that if I was offering non-financial contributions, if I was giving some type of support and it can be proven, I'm also entitled to something that is fair and just and equitable. And I think this is a big win for Muslim women, unfortunately, where there are Muslim men that are not doing the right thing. The Divorce Amendment Act thus introduced the following changes: to insert a definition of a Muslim marriage, to provide for the protection and to safeguard the interests of dependent and minor children of a Muslim marriage, to provide for the redistribution of assets on the dissolution of a Muslim marriage, to provide for the forfeiture of the patrimonial benefits of a Muslim marriage. The amended legislation addresses shortcomings in the Divorce Act of 1979, which differentiated between people married in terms of the Marriage Act and people married according to Muslim rights, especially women, said the presidency. Very, very important law for the Islamic or the Muslim community. One of the points I forgot to raise in the previous article, I don't know if it's been altered or not, but it must be. Last I checked, if it's amended, brilliant. If it hasn't, something to look into. South African law does not allow you to be in both a civil and a customary marriage. What does this mean? You'd have, you would have umfazi wephepha, a wife, a paper wife, civil marriage. In South Africa, if you marry a woman in a civil manner, you go and sign at a Home Affairs, you cannot be in a polygamous setup. That second wife that you marry customarily because you pay lobolo, you send cows, you guys have a celebration, the first wife can go and challenge this in court and deem that second marriage null and void. And that normally comes up when you guys are getting divorced. And you're saying, I'm entitled to these things. And he says, but I've got another wife. Nope, that marriage is null and void. Or there are children. Or the man passes away and the second wife customarily comes and says, well, I was married to him. This guy wang lobola, there was a ceremony at home, I'm his wife, everyone knows, we maybe even have children. That would be null and void. And that is something to be looked into, because the late king of the Zulus, uZwelithini, would have an issue like that when it came to succession of the throne, where after he passed on, one of his later wives from the Swati nation would take on the kingship, the queenship, as being the leader of the Zulu nation. She would then pass on, and then it would succeed to her son, the current king of the Zulus, uMisuzulu kaZwelithini. uZwelithini had married me under civil, and all the subsequent wives and their marriages are null and void and invalid. Therefore, anything he owns should come to me as his first wife, his civil wife. There had been that clash, because the law, last I checked, was if you married under civil and you want to go into polygyny as a man, you need to divorce your civil wife. You need to then marry her customarily, and then you can go and get permission from her to then marry any subsequent wives, of which, last I checked as well, the law said even if you're married to a woman customarily, if she does not approve of you getting a second wife, a third wife, she could challenge for the invalidity of these subsequent marriages. I don't know if that has been fixed or not. There are a lot of black men who are getting married on the sly. They have a wife at home, they meet a girl they like, they maybe have a child or two, and all of a sudden, without reporting to the first wife, without telling anyone else, they go with their family members to go and lobola this woman. And then this woman is like, oh, I'm the second wife. And then when this guy passes away, when something happens in terms of divorce, or when they split, she goes to court, and for the first time she finds out, but your marriage is not valid, especially in situations where these marriages have not been registered. Because sometimes it's upon trying to register a customary marriage where they say, oops, this man is already married in civil. Yes, I'm his second wife, I'm aware. No, ma'am. No, if he's married under civil, we can't register this marriage. Again, if this has been changed and amended, which it should be, then no problem. My suggestion and my hope, and what should happen, in my opinion, African customary, Muslim customary or religious, civil, Christian, whatever it is, when you guys decide to get legally married, please go and register your marriage at Home Affairs. And any marriage that has not been registered at Home Affairs should be deemed null and void and invalid, under exceptional circumstances. So, you guys are the ceremony, and then in 3 weeks, you guys are planning to go to Home Affairs, and then the man passes away, as an example. Or you guys get married, your wife gets a job opportunity overseas. She's like, let me go and see what's going on, babe. I'll be back in 3 weeks' time. Something happens in this 3 weeks. She finds out you have a child with someone else. She maybe meets someone else, or you find out something about it. It's like, nope, we're calling it off. And it's like, no, but we'd already started the process. We've been living together. We are married. So we're like, okay, this one maybe can be exceptional. And it can be as if they were married and now they should be getting divorced, as an example. But for me, to make these things easy, because it seems like the courts and the lawyers and the Constitution are the supreme law when it comes to unions and marriage, every single marriage should be registered at Home Affairs as standard procedure. And if it is not married, if it is not registered, especially within a certain window, it should be deemed null and valid. Because what will also happen is when you go and register it, you will then find out that your husband, that your wife is already married, or never got divorced, or has got something else written there, because Home Affairs will know, but you know this person has children, you know this person has this, you know this person is actually not a South African citizen, you know this person is not in South Africa legally, and fundamentally important. This is the last article. We've reached almost the end. BusinessTech.co.za again, written by Malcolm Libera, 3 August 2025. It's just from like recently. Big changes to who gets what after divorce in South Africa. Again, it starts off with something similar. Justice Minister Kubai is preparing to introduce new divorce laws in South Africa by presenting the General Laws Amendment Bill 2025 to Parliament. Let's see if there's anything new here that hasn't been covered already. The proposed changes to South Africa's divorce laws could usher in a major shift in how marital property is divided, especially for spouses who have been left financially vulnerable after years of unpaid contributions to a marriage. Let me actually stop there and say something. before I carry on, because maybe there's going to be a lot of repetition. I said to Tusiswami, a lawyer, Uzolambata, and she was speaking about the cost of dying and how expensive it is to wind up in a state. The whole process, there's 10 steps that she speaks about. She's posted on her TikTok page. And we even touch on this concept of men especially, but it could happen to anyone. Men who give girlfriend allowances, who send e-wallets, men who are paying the rent of a woman somewhere, or who are contributing to a stepchild somewhere, need to be very, very careful. Very careful. Upon splitting up with that person romantically, upon getting divorced, upon your death, these people have got legal claims of dependency, and they can take this to court. This person was paying my child's school fees. Yes, but he's a stepfather. Yes, but we are dependent and we see that he's got money and we'd like him to pay. There are literally cases that I've spoken about on podcasts to speak about stepfathers that were ordered to continue providing for their stepchildren, even after splitting up or divorcing the mom. Girlfriend allowances. This thing of thinking you're a big baller and you're sending some girl 5,000 Rand a month. Reference girlfriend allowance, reference I love you, reference to my baby boo, reference thank you for last night. Those amounts that lady can put together. And the day you leave her, the day you want to get married, the day you pass away, can potentially have a legal claim to say, this man was taking care of me and I'd like him in his death or in his whatever to carry on taking care of me. The sending of the e-wallets, the paying of rent. Some of these men who are high profile, politicians, judges, CEOs and big business guys who are married with a family, but who've got a side chick who's at university or is a young graduate somewhere that they're paying rent for because they want to prove it's acceptable. I mean, so I'm going to pay you 7,000 Rand rent. Maybe I'm letting you drive a car. Could even be in my name, could be in your name. I'm paying installments. The day we split, this lady can go and lay a claim. Very, very dangerous, gents, that we need to speak about. And for women, you're trying to be woman of the year and you're sending this guy money and you're taking care of him and you're housing him in your house and maybe he's got children and you're like, no, man, I'm not like typical girls. I'm not a feminist. So I love him. Because I love him, I love his children. So I'm going to pay his children's school fees. I'm going to pay his children's medical aid. I'm going to buy his children clothes. That man could go and take you to court for child maintenance when you guys break up. So be very, very careful in this regard. See here, referencing Bertus Preller, who was referenced in Moonstone from the blog. Let's see if there's anything that's been here. He explained that the current law is especially harsh on spouses who stayed at home to raise children or manage the household while their partner advanced financially. Be very careful of this thing of sitting with your partner, and it sounds so cool. Well, my man is the provider. We sat down and we agreed that, oh, this is why I actually made a point. I wanted to stop. He's going to make the money. I'm going to take care of the family. So you'll find yourself in trouble. This is actually what I wanted to say earlier. This is from me. This is just from me. Other people can debate and argue against it. Men, women too, but men, stop giving women money just for existing. You're going to find yourself in trouble. It doesn't matter how much you love a woman. It doesn't matter if you're trying to marry her. Only give a woman money for services rendered. And as far as possible, YouTube is starting to buffer. It's not feeding. If it's on Microsoft or Microsoft Excel, try and send a payslip. Try and put together invoices or have her invoice you. It sounds stupid. I know, it's ridiculous. Invoice her for cleaning of the house, for cooking, for doing laundry, for looking after the kids, for driving the kids to and from school, all of these things. And then you guys should sit down and agree on what you're paying for. So you're giving her rights of usage of a car. If you can, draft a contract. There's one celebrity now, I forgot who it was, who's drafting some contract with his living spouse. I don't know if it's John Cena or someone. Sit down and say, look, these are the things that I expected. I know it's not nice, it's unromantic, it's not cool. These are the things expected from you as a woman. These are the things expected as a man. Is there a financial consideration? Should we be doing pay slips, invoices, etc.? Such that when you guys split, when you guys break up, when there are issues, and this person comes and lays a claim, you will say, no, I was paying her for these services. And even after paying her for these services, she was contributing towards rent. Yes, she was paying rent from the money I was giving her, but it was for services rendered. It wasn't just because she's got a fat ass and she's pretty. No. She offers services and I was paying her. This could even apply to married couples. This will ensure some level of fairness. I will only pay you where you are offering services. If we're going to be going on a weekend away and you're going to be giving me ideas for my business, let's call that consulting. And I will either pay you in cash and then you'll contribute to the trip, or I will pay you by saying I will pay for the trip and your accommodation and everything because of the value that you're adding. This will help sort out a lot of things that you guys are not really sure about. It is not nice, it's tedious, but it will create a very clear picture of who's contributing what in this relationship. Even if you're paying her 20,000 Rand a month for doing your laundry and you're sending her reference salary, it'll also help a lot of housewives to be able to have pay slips that they can use to go to the bank to get credit products, personal loan, a car loan, a home loan, and they can call you as a reference and you can explain yes, and they'll verify and they're like, okay, we can see you pay her every month, the same way you pay a nanny, a tutor, a babysitter. This is income. And then you can hold her accountable to also pay for her own things and to contribute towards, because you are doing that together as a couple, and it makes things easier. One of my biggest frustrations with divorce laws is normally the spouse that is going to carry on contributing financially. So I must still send her 10,000 Rand a month, but I'm sending her 10,000 because she's contributed over the years, but she's no longer now cleaning my house. She's no longer doing my laundry. She's no longer cooking for me. She's no longer offering some type of emotional or business advice in my struggles. She's no longer taking care of my mom. She's no longer helping with the stepchildren, my other children. But I must still keep giving her money. There's an unbalance there. Why am I still giving her money when I'm not getting the benefits? So let's have the conversation, because while she was living with me, yes, she wasn't getting money, but she was getting a roof over her head, which comes at a cost. She was getting food, which comes at a cost. She was getting right of usage of maybe a car. She was enjoying maybe pocket money. She was enjoying other perks in my life. That was the value. But now she's leaving and I don't get those benefits, but I must keep paying her. Something must be sorted out in that regard. Let's see here. Women in those circumstances would only have a maintenance claim in a long-lived marriage, which was completely unfair. Let's see if there's anything else. The new laws are not retrospective, very sadly. This redistribution right would also extend to cases involving death, not just divorce. Previously, if a spouse died without a will, the surviving spouse in a non-cruel marriage might be excluded entirely. Now, that wife, like in terms of an accrual case, would have a claim for the redistribution of assets. And then pointing out to the Bwanya Constitutional Court case, which I referenced earlier. Despite the positive steps forward, Preller warned that inequality remains. Even in accrual marriages, wealth can be shielded through legal structures. Oh boy. And we have a lot of these chats with some of the guys that are in the know. Offshore trusts somewhere, layers and layers of admin. And unless a woman has a lawyer that is normally very expensive, you won't be able to rumba and find out where this guy is hiding his money. You can actually contract out. You can put assets out of the reach of the other spouse by naming them as excluded assets, he said. This often happens through trusts or other mechanisms, particularly in high net worth cases. Preller still believes the changes are fair and restored the discretion that courts had before 1984 to allow equitable transfers of assets in divorce. However, he cautioned that this new mechanism can only be triggered in divorce trials, not settlements. You're going to see a lot more contested divorces, in my view, going forward, he said. He acknowledged concerns about potential abuse, where one spouse may choose to not work and still claim part of the estate. However, Preller emphasized that courts should consider the facts of each case. So before your woman tells you, I'm a traditional woman, I want to take care of you, daddy, I want to take care, be careful. That woman may be choosing to not commit, to not marry you, knowing full well legally later on she will have a claim on your estate because she was tricky. And the courts and the lawyers need to be very careful about this. If someone deliberately does not contribute, the court has the discretion to transfer a percentage of the assets from 10% to half of the estate, he explained. While the law is gender neutral and will apply to all spouses, Preller noted that the majority of cases will likely involve women, including those in Muslim and same-sex marriages. It's not only women. We see a lot of cases where the woman is the breadwinner, he said. In those cases, a husband who played the homemaker role would also be eligible to claim redistribution. However, the news is less hopeful for those already divorced under the old system. The new rules will apply only to future marriages and current divorce cases that are still pending. That's the sad part. If it were to be retrospective, the court roll would be completely flooded. businesstech.co.za. And that concludes what I wanted to raise today. The history of marriage. Husbands can now take on their wives' surnames, or it's something that's been contested. Courts can override the prenup or the antenuptial contract without accrual during a divorce. Treating a girlfriend, boyfriend, your spouse, as a husband or wife or marital spouse upon death. Legalizing polyandry, as you heard about the case of the pink pit bull in Durban. And then Muslim marriages are now recognized legally, which means Muslim wives can now go and apply for divorce and be entitled to whatever assets are fair for them. I hope this has been educational. I hope you've learned something. I hope you'll be able to protect yourself, protect your loved ones. Please share this video with whoever you know that's married, whoever you know that is considering getting married, anyone who's living with their partner, anyone who's sending a girlfriend, boyfriend allowance, people that share children, people that are step parents, and anyone else. Because like I said, this could save a life, it could save you a lot of money if you proactively understand the laws that are here before us. Thank you to everyone who contributes to my channel as a viewer. Thank you to everyone who contributes as a subscriber. Thank you to everyone who donates the super thanks to my channel and who supports all my other social media platforms. Have a great and blessed day, and I'll catch up with you guys again soon. Penuel, the Black Pen. Stop getting married.